Sir, I rise on behalf of my party. I heard my illustrious and senior colleagues here who manifested justified sentiments and emotions. We have been witnessing that in and out of the house. The manifested emotions is the response, and this must be the response to all incidents of atrocities on women. Whenever any atrocity on women takes place, such outburst of emotions for justice must be there. We respect this emotional outburst and fully share their agony and anguish. We have seen this after the Nirbhaya incident. The country collectively displayed its agony and anger after the gruesome incident which happened 3 years ago in the capital. As far as our party is concerned, we were a part of the collective struggle in the demand for justice that took place in the streets of the country. The media for the last few days have been constantly creating an environment that after the passing of this bill in the House, it becomes an act and the criminal who has committed this offense will be sentenced. The media is constantly trying to do it. It cannot be corrected. The point that I want to make on behalf of my party is that everybody here knows that it cannot be corrected here just by passing a law, and the law cannot be applied to the person who committed the crime, as no retrospective effect will be there. We have to basically define the intensity of the crime. I repeat this once again that defining the intensity of the crime is the moot question. The moot question basically remains the crime, the heinous crime, needs to be defined, not the age. The House has to deliberate on it, and God forbid, people may say, why I am saying God forbid? Still, God forbids that after passing this law, if somebody aged 15 years and 11 months commits such a heinous crime, what will be our response? Will we again amend the law? This is a very basic question. As the Honorable Minister is here, I just want to know this from her. The UN Convention on the Rights of the Child requires all signatory countries to treat every child under the age of 18 years as equal. The provision of treating juvenile as an adult contravenes the convention. My senior colleagues have pointed this out, and the leader of the House also spoken about that. I also felt after going through the bill that some penalties provided in the bill are not in proportion to the gravity of the offense. It has already been mentioned that the penalty for selling a child is lower than that of offering intoxicating or psychotropic substances to a child. One thing that my party feels is that the standing committee which examined the bill observed that the bill was based on some misleading data regarding juvenile crimes and violated certain provisions of the Constitution. We feel that while there is a need to address serious crimes committed by juveniles, the present amendment moved by the union government will not serve the purpose and is retrogressive in nature. The solution to the problem has to be thought of within the parameters of the Juvenile Justice Act itself. This can be done by strengthening the institutions under the Act and by ensuring that the juvenile who has committed such a crime is not allowed to repeat the offense and intimidate the victim again. Sir, the punitive measure of transferring the juvenile to the ordinary criminal court is based only on the retributive theory and revenge and does not act as a deterrent to future juvenile criminals, but in fact it results in recidivism. It only further brutalizes the juvenile who is already in conflict with law. We have the examples of the United States of America, where in every school you have the culture of gun going on. Guns have penetrated what is there. We have seen that. Now, sir, I have heard when this debate was going on in the other house. Questions were raised by honorable members in the other house regarding the United Nations Convention. Madam is seated here. She had said that there. I heard that debate that the bill did not violate the UNRCC. Now, Madam, Article 1 of the UNRCC clearly states a child means every human being below the age of 18 years unless under the law applicable to the child majority is attained earlier. On the issue of treating juvenile as adults, the CRC has unequivocally stated that states parties which limit the applicability of their juvenile justice rules to children under the age of 16 or lower years, or which allow by way of exception that 16 or 17 years old children are treated as adult criminals, change their laws with a view to achieving a non-discriminatory full applicable of their juvenile justice rules to all persons under the age of 18 years. Now, Madam, while speaking today here in the House, mentioned about the child friendly objective. Now, as far as this is concerned, I want to mention here that to determine whether the person has a childlike mind or not, the assistance of psychologists and psychiatrists will be taken to ascertain that. How will it be taken? This very notion of determining a childlike mind is fallacious and needs to be countered, as scientific studies have clearly established that such individualized assessment of adolescent maturity is impossible. This is confirmed by senior professors of the Department of Child and Adolescent Psychiatry, NIMHANS, who have stated the frame of mind of a child and adolescent is not an easily understood paradigm and does not lend itself to be measured accurately. What is being proposed? Identifying the frame of mind of an adolescent who is only alleged to have committed a heinous crime will merely result in an arbitrary opinion lacking scientific validity. Now, sir, it is also relevant to mention here when we discuss this that most of the juvenile 50% who were apprehended belong to the poorest of poor families.